Good day, ladies and gentlemen. My name is Mark Rollins. I'm a criminal defense attorney here in Washington, D.C. Today, we're talking about diversion options for a misdemeanor case in D.C. And specifically, this is talking about a Deferred Prosecution Agreement and that agreement and what to expect on a Deferred Prosecution Agreement. Usually, you're probably sent this video because your attorney has discussed with you that deferred prosecution may be an option here, and that may be the option in which the parties are going to go. So let's talk about what a Deferred Prosecution Agreement really means. All right, so you've already been to court once already, and that was referred to as an arraignment. And you've been to court, and now your next court hearing is called a status hearing. Now, the status hearing is exactly what it sounds like. It's a status. The judge wants to know what is the status of the case. And essentially, the judge is like, there's three options here, and your lawyer probably told you that. There's three options that you can have at the status hearing. The first option is to have a trial, and you could have a trial. If you had elected to have a trial, it would not be at the status hearing. It would be in 45 to 60 days from the status hearing. So if you wanted a trial, you would say to the judge, I want a trial, and you would have a trial in 45 to 60 days. It could be longer. Doubtful that it would be less than that. So you'd have a trial in that period of time. The other thing you could do at a status hearing is you could plead guilty. Don't recommend it, but you could plead guilty at a status hearing and just say, all right, I'd rather just plead guilty and go to sentencing and let the chips fall where they may fall. The other thing, the reason why we're talking about this today is because you could enter into a diversion agreement. Now, the diversion agreement that we're talking about today is a deferred prosecution agreement. Now, there are several different types of diversion agreements. This one is a deferred prosecution agreement with the U.S. Attorney's Office and what that would require. So, a deferred prosecution, exactly what it sounds like, it's deferring the prosecution of the case. It's diversion. What is diversion? So, diversion is simply an alternative way to resolve the case with getting you out of the criminal justice system, usually without a conviction. So, there would not be a conviction here. And it's exactly what it sounds like. It diverts the case off the trial track. It dismisses the case with no criminal record. So you're pretty much guaranteeing what's going to happen here if you participate in diversion. If you do what everyone's agreeing to do, the case would be dismissed. You won't have a criminal record. It usually requires some goodwill from you. Now, what is that goodwill? That goodwill could be restitution. It could be community service. And 99% of the cases dealing with deferred prosecution agreements are community service. Let's see. This is what the deferred prosecution agreement looks like. And if you look over here, you would have your name would go here, the case here. There may be a stay away in place. There could be curfews. This is very rare for curfews. There could be restitution if you broke something. And there could be other conditions. But the big thing is right here, you can barely see it, is 32 hours of community service. You also must not violate any law or be arrested on probable cause. And you must not violate any court order. And the big deal here is 32 hours of community service. And that 32 hours of community service must be performed over the course of 4 months. And it's a 4-month deferment. So essentially you have 4 months to do that community service in, which breaks out to about 8 hours a month. And obviously you must abide by all the conditions of this agreement, and generally this is exactly what the conditions are. So some of the other language in there is actually not that important, but if you complete those things, the case would be dismissed, and you would, at the conclusion of the 4-month time period, and all the conditions are met, the prosecutor will dismiss the case with prejudice, meaning that they will never or can never bring the case back up. Now, I know a lot of people saying, well, what about, will I still have a record? You will not have a criminal conviction on your record. You would have an arrest. That arrest can be sealed based upon the charge in the statutory period of time. So there would be no criminal conviction. You would have the arrest record. So there would be the arrest record would be there. But like I said, that arrest record could be sealed within the statutory period of time. The statutory period of time is different for different offenses, but generally 2 years from the date of the dismissal. So as I said, and you'd have the ability to seal the rest after that statutory time. If you have any questions, you can always give us a call. There's our information on the screen. And like I said, if you have any questions, feel free to reach out to us. But that is what a deferred prosecution agreement is and what it would look like in the district.